Hi there, my name is Vanessa Carter, and I'm a real estate attorney with the firm of Woods Rogers, Vandeventer Black. And today, with my colleague Ray King, I'll be discussing the 2,000-foot view of real estate foreclosures. Now, this is not intended to be a CLE or a checklist for foreclosure practitioners. It's more of a guidance and, like I said, a 2,000-foot view of foreclosures in Virginia. Before I continue on, I did want to plug the Virginia State Bar's Real Property section. There's a lot of amazing real estate practitioners in our section who have helped me tremendously throughout my career. I really recommend that anybody interested in foreclosures join the section because there's just excellent folks there to work with. I started out performing high volume residential real estate closings and then transitioned into the unrelated world of debt collection, performing credit card collections and student loan collections. When I then joined a prior firm performing foreclosures, it was a good marriage of real estate law and debt collection law. Right now at Woods Rogers Vandeventer Black, my practice focuses on commercial real estate closings. So when I talk to you about Virginia residential foreclosures, this is really the intersection of debt collection law, real estate law, and contractual law. The foreclosures in Virginia are governed by the terms of the deed of trust, the Virginia foreclosure statutes, and sometimes if the deed of trust incorporates federal regulations, it'll involve that federal law as well as debt collection law. The deed of trust will have within it certain pre-acceleration requirements, but it's also important to know whether or not your debtor is currently in bankruptcy, which would prevent the beginning of the foreclosure process. If your debtor is subject to the Service Members Civil Relief Act, which if your debtor is a active duty military service member and their loan originated prior to their active duty service, you may need to get judicial permission to foreclose. But the deed of trust will also explain whether or not as a foreclosure trustee, you would need to send something like a demand letter, and it'll also include the time requirements and the content requirements of such a letter. Virginia attorneys who want to start performing foreclosures will need to become very familiar with the different forms that the deed of trust takes, and they'll also be able to determine whether or not that deed of trust incorporates those federal regulations. So one example is if you have an FHA loan, then the deed of trust might incorporate regulations related to lender requirements to perform a face-to-face meeting prior to acceleration. The fact that these deeds of trust can incorporate these federal regulations is part of the reason why during the early years of the COVID pandemic, there were a series of moratoria covering government-backed loans. Now, Virginia attorneys looking to foreclose will also need to make sure that title to the property is clear. Although you're technically able to foreclose on a less than complete interest in a property, your lender clients would not be pleased to learn that there are missing interests after a foreclosure sale. Before the foreclosure sale takes place, you'll have an opportunity to clear those title defects using various means. But very important to determine, number one, that you have clear title to the property. Number two, that your encumbrance is valid and perfected. And number three, to determine where your lien is in the list of priorities for liens. If your lender client is seeking to foreclose in first lien position, it might be an unhappy surprise to discover after the sale that the lender was actually in second or third lien position. Now, determining whether or not the FDCPA applies to your foreclosures is very important. Certain foreclosure trustees are within the purview of that, and certain foreclosure trustees are not. So very important to be familiar with debt collection and debt collection laws. And it's also important to be able to respond to certain debt collection attacks by consumer protection attorneys. Virginia has a lot of very robust consumer protection attorneys. So being able to do everything, perform everything as required under the deed of trust and federal and state statutes will guide you in responding to those lawsuits. Ray and I will discuss foreclosure in more detail, but we do want to let you know that if you have any questions about foreclosures, please contact us and we're happy to speak with you. Thank you.